Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest. Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm from the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. Late evening U.S. people. Hey, all right. Good morning, good afternoon, good evening, good night, everybody, wherever you are, whoever you are, whatever you're doing, whoever you're doing it with, however good it feels. It probably feels better than I feel right now, but hey, I'm getting better. Wow, my mic is super hot, just like me. Let me. Am I muted? Please tell me I'm not muted. For somebody, for the love of God, it could be. Hang on, I'm doing 3 things at once here. Please. Oh, good. I'm not muted. Phew, thanks. All right. Because normally if things reset themselves and my mic gets super hot, then that means I'm also muted. So we're good. All right. All right. There we go. Mic is now set. Yeah, there we go. All right. Everything is situated. Now I have to turn off my own volume. There we go. Okay, peeps. Sorry to be a bit late. I realized that I had not for some reason my downloads that I did on my Office to my Google Drive or my Microsoft OneDrive had not synced, so I had to hurry and run off to Reddit and download some of the documents for today. So there we go. The mic being low is I mean that's your problem. I mean, I can make the mic hot if you want, but this is the comfort zone. This is where we are all the time. We're not going to have any video, so just bump that volume up and see how you like it. If you're caring about my feet and how I'm doing on the foot journey through acute tendonitis, extensor tendonitis in both feet, I think there's some improvement, moderate improvement, very mild improvement. But I noticed normally I wake up, the last 5 days I've wanted to wake up. I just wake up wanting to die, wanting to just chop my feet off and go about my business. But today I didn't really feel like I wanted to chop my feet off until about 2 p.m. And I noticed when I woke up, I could slide my left foot, which is the most swollen, a little bit further into my slippers. So I think there's some improvement on day 6 of
the tendinitis. The doctor says don't even think about feeling anywhere close to normal for at least 2 weeks. So, but yeah, I'm optimistic. I'm guardedly optimistic there's some improvement. So that puts me in a little bit better mood, but I'm still just cranky AF, you know, it's just this constant thing. So I haven't cleaned my house in like 5 days. I haven't shaved since it happens. I'm getting all scraggly but I just need a little bit of peace of mind, and then I'll be able to get back to normal. But we're doing good today because we've got some motions, we've got some evidence, we've got some Jane Doe and John Eckert business to take care of today. So how are we all doing? We have everybody here. We got 225 here. I was going to go down the list and say hi to everybody I could, but we've got 225 people here already, so I can't do that. So anyway, to the 237 of you that are here now, welcome to take care of very quickly the housekeeping. Make sure you hit the like button. Make sure you hit the subscribe button. Subscribe button is important right now. We're pushing for subscribers because we are 90 subscribers away from hitting 67,000. That's the push. I want to get up to 67,000 subscribers. Right now we're at 66,910. So we have exactly 90 to go before we get to the magical number of 67,000. So help me out with that. If you haven't subscribed, please do. If you are subscribed, please double check to make sure you are still subscribed. I'm just double checking here to we're up to see one more. We got 9. We got what do we got? 89 left to go. So that'd be awesome if we get to 67,000. Say by the end of the week, that'd be a great goal. We could do it today if we all tried really hard. But we won't mention that much. We'll just mention again a little bit later, about an hour into the show. We usually do about halftime. So once you've hit that like button, once you've subscribed, go over and take our daily really lame, terribly unfunny, and just generally nuisance poll to remind you to hit the like and subscribe button. Your favorite euphemism for her condition: Tonsil Twins, Crusty CLAYTONs, Jane Doe, and mouthconceptions. Currently, 9% of you are in favor of Crusty CLAYTONs for her condition. 16% of you are for Jane Doe. 24% enjoy the term mouthconceptions, and 52% Tonsil Twins. We'll see how that shapes up during the rest of the night. Once you've liked and subscribed, vote for your favorite euphemism for her condition. And all right, before we jump into these motions, we got to take care of a little bit of a super chat business again. I'm going to try to watch when I'm reading the motions. It's a lot harder to pay attention to chat and to get directly involved. I mean, this isn't a grift, it's just a fact. Super chatting, that guarantees you'll get your comment noted and read because it comes up in bright colors and it distracts me and it turns my head. And that guarantees you'll get your comments, questions read and responded to. Otherwise, I'll do my best. That's the best I can tell you, is do my best to get to the other ones. Speaking of super chats, Jinver with that £2 to kick us off for the morning. Hope you're feeling better today. I just kind of gave the lowdown for that. Oh, and while I'm sitting here, for those of you that were watching the unboxing yesterday, Smopo Vienna made me this amazing handcrafted face cover. It's a hey, cool. I just noticed there's kind of even a face in the face hugger. The face hugger, alien face hugger ceramic pipe that, I mean, you could use this thing as a weapon. Like, this is like Walking Dead material. I said I was going to light it up today and give it a try, but I will do that tomorrow because tomorrow we'll be doing the Zachariah Anderson police interrogation video. We'll see what happened there, what went wrong, what went right, and when we have the video on, we'll be able to light up the pipe. That's what we've got coming up for this week. By the way, tomorrow Zachariah Anderson's police interrogation video is released and ready to be watched. We'll do that tomorrow. Thursday will be O.J. Simpson Day, where we continue watching the closing arguments by Johnny Cochran. If you want to see some of the most amazing closing arguments, the most inspiring closing arguments you'll ever see, tune in for that. Friday, we'll be talking about what's the kid's name? Aguilar Mendez, the Guatemalan 18-year-old boy who was assaulted by cops and was charged with aggravated manslaughter of one of the officers because the cop that had arrhythmic heartbeat hardening of the arteries. I think he had clogged arteries as well, bronchitis, and they said, I don't know if I mentioned high blood pressure, but he had all of these things, and he dropped dead a few minutes after the arrest, and they charged him with aggravated manslaughter of the police officer. So we'll be doing some more about that. There's a bond motion. There might be some other motions coming soon that we'll do, so stay tuned for that on Friday. So I'm feeling great, and we got some great stuff coming up, so subscribe and stay tuned. By Franz, who's been a member for 3 months, says, what's on the thumbnail? What is the thumbnail for this? I don't know what the thumbnail is for this. The thumbnail should be, let me go over here and check. The thumbnail. The thumbnail is me and Clayton. Oh, you mean in the middle? Oh, that's the boiled rabbit from Basic Instincts. Not Basic Instincts, Fatal Attraction, because of Megan Fox dubbed it Fetal Attraction. So yeah, the kind of opaque mid thing on the thumbnail is the boiled rabbit from Fetal Attraction, from Fatal Attraction. Sorry. And Bella Stella with the $10 says, Jeff. Hello. Well, hello, Bella Stella. Good to see you here. And Aaron has been a member for 7 months. Thank you so much for your support, Aaron. Thank you, Bye Franz, for your support. And thank you, Jennifer and Bella, for these super chats. We'll read more super chats as they come in. Right. There we go. Let me scroll down here to the bottom of the, here we go, to the bottom of the comments. OMG, Jeff is crazy. You're just now figuring that out. But I'm just happy because we can get into this. I think my head is swollen. Even my hat's not fitting properly these days, damn it. It's kind of off kilter too. Anywho, all right. It's time to get into these motions. What's happened? What is the update on this? What is, as you all may remember, if you've been following this case, we've got a no-show. There was a no-show at the deposition. She was supposed to show up. She just ghosted the court-ordered deposition. And we had no idea what was going on. She just didn't show. But we've come to find out what happened because there were some documents filed, and we're going to be reading those. There's one thing I wanted, and I forgot to bring up the damn article. Just a quick second here. Let's see. I'm looking for a specific article in Cosmopolitan. There it is. No. Dang it. Hang on. Because there's a couple of other cases I wanted to bring up in relation to this. And this is all completely my fault. That I didn't. Let's see. All right, that's one. It's an article from Cosmopolitan. All right, I'm going to do this here. Her name is Caitlin Braun. Caitlin Braun. I so apologize for this. All right. This is probably not the article I wanted. Yeah, it's not. Okay, all right. I can't find this on the spur of the moment. We'll have to do this during our next Jane Doe, Eric Clapton. I almost said Eric Clapton. Clayton Eckard stream. But there's two cases I wanted to talk about. One is this woman in Canada. Caitlin Braun is her name, and she has apparently been tricking a bunch of midwives in Canada, these doulas, into helping her deliver fake babies. She faced like 52 criminal charges of scamming and duping Canadian doula midwives into helping her online deliver fake babies. It is completely bizarre. It is wild. It's crazy. And I wanted to read that, but I can't find the dang Cosmopolitan article about her being convicted and whatnot. I didn't have her prepared. I apologize. And there's also another story that we mentioned on my F It Friday that I wanted to talk about, which we'll also talk about next time, where it was someone who actually did apparently get pregnant from a blowjob. Yeah, it may not have happened in this case because the fact pattern is just a little bit different. There is a story of a woman who apparently became pregnant through oral sex. And we will talk about that next time as well. But that story in a nutshell, she filleted a young man and swallowed his man gravy, ingested it into her stomach, and was shortly thereafter involved in some sort of knife fight where she was stabbed in the abdomen, lacerating her stomach and her lower abdominal cavity. And apparently, while they were cleaning out the wound, they think that some of the sperm was washed from her stomach into her reproductive areas, and she got pregnant. Now, how do they know this wasn't pregnancy by another means? Because she had a genetic defect where she did not have a functioning vagina. They described it as a dimple of skin with, a tiny hole for taking care of business. So yeah, there was no way for her to get pregnant any other way than the way they hypothesized, through the knife fight. So be careful. It could happen. But as I said, the fact pattern in that weird case we'll talk about next time is slightly different than what we have here on hand. I'm serious. Yep. Yeah. I seem to have broken chat. New fear unlocked. Just stay away from knife fights, and you should be okay. As they say in Jurassic Park, life will find a way. No, been there, done that. No, it was genetic female. She just didn't have a functioning vagina. Exactly, Nancy. Great minds think alike, don't they? We said that like at the same time. That was nice. Yes, Tom Waits did sing a song about Civil War bullet pregnancy. There is that story that unfortunately has been debunked, but it makes a hell of a good story, where this other story is fully documented. But now we'll keep that out of the way for a while. We'll talk about that next time. All right, so we've got sorry for chat. There you go, Kaiser Pineapple. That's a real story. Someone said it's apparently been debunked, unfortunately. That's what I had heard about I think it was last year sometime when I finally deep dove that. But anywho, let's talk about Jane Doe for a minute. Today, unfortunately, we only two of the three documents are redacted. Her name is taken out of only two of the three documents. So pretend you don't see the name Laura Owens. Just, train your mind to see where it's all caps and bold Laura Owens. Train your mind just to see Jane Doe. All right, the first thing we're going to look at here. Oh, what is wait, what's my computer doing? Nothing important, but if I go quiet for a couple of seconds, it's just that. All right. This is the notice of non-appearance at deposition pursuant to Rule 57G. Now let me bring that on up for y'all. Window. Boom. Here we go. Yeah, I know. The reason we call her Jane Doe is, as I mentioned in the chat, when someone's like, "Well, why are you calling her Jane Doe?" Because that's how Dave Neal handed the case to me, calling her Jane Doe. So I just continuing on with the joke. That's one reason. Two, I just think it's funny to call her Jane Doe. And three, I just don't really want to say her name. I don't want to give her any more credit, any more notoriety, any more anything that she already has. Get out from underneath the table there, dog. Stop it. Now is not the day to lick my toe. It hurts. All right. Sorry, Straubs. I love you. We'll play later. Yeah. So I just think it's funny. So it's funny, and I don't want her to have any more notoriety than she already has. So let's get going with this, shall we? Let's see if we can make this any bigger. That's what she said. Hey, we can. What do you know? All right. Is that too big? That's also what she has. No, I guess that's pretty good. All right. Fine. This is what we're going to do. Respondent. So this is not Jane Doe sending a letter saying, "I'm not appearing." This is respondent Clayton ECHARD, by and through the undersigned counsel and pursuant to Rule 57G, hereby notifies this court that petitioner Laura Owens, Jane Doe failed to appear at the properly noticed deposition schedule for January 17. This is ECHARD's lawyer ratting her out, going, "Hey, judge, just so you know, the woman that was ordered to attend the deposition, she didn't show. She was a no-show. She wasn't here. She violated the order." Yeah. This is them saying, "Hey, just wanted you to know that counsel conducting the deposition was notified the day prior to the deposition that petitioner was not going to attend." There's some emails attached to this. There's a couple of email exchanges between ECHARD's lawyer and Jane Doe's new lawyer that are actually really funny. It makes me feel nothing but sorrow and pity for Jane Doe's new lawyer. It's sad. It really is. Oh, hang on just one quick second. I think this might be where we cut out for a couple of seconds. All right. Just kind of waiting. I'm going to keep talking, but we'll come back in just a second. Hey, stop going blue, dude. All right. Hey, stop being blue. There we go. Right. Okay, we should be back. Right. The day prior to the deposition, they found out that she was not going to be there. Jane was not coming. Unfortunately, ECHARD did. Petitioner and her former counsel. I love ECHARD's lawyer. When all of this is over and done, I want to get his lawyer here on with me on this stream to talk, because this guy has an amazing sense of humor, and he knows just how to just push the buttons and squeeze it here. I mean, and her former counsel, and like how he puts the S and he underlines the S to mention that she's had more than one, and to emphasize that she's had more than one previous counsel. I like the snark. I like the snark of the underlining the S in counsels. Jinver with the £5 says, "Jeff, tell Flux that tonsil twins and sweater puppies are only related if you dribble." No, I'm not going to tell her that. You tell her. You already did. Damn it. Don't make me read things like that. All right. Dang. So petitioner, Jinver, shame on you, and her former counsels were previously noticed and agreed to that date of the deposition on or about December 28th, 2023. Again, highlighting that they were notified. They were notified, and they agreed to that date. Notably, when petitioner obtained a new counsel, She did not request an extension of time or otherwise indicate she would not be prepared for the deposition. And Special KL gifted one Legal Vices membership. If you got that, if you were the lucky soul of the 443 of you here right now that got that Legal Vices gifted membership, make sure you give Special KL a super special thanks. And Rosalind Duke with a $10 super chat, putting us well on our way to Doggo Cam. Electrolytes, they will help. Also, lidocaine patches. I've developed a tolerance to iocane powder. Sorry. Constant pain is my normal. White potato, ginger, and turmeric poultice compress if you're desperate. I use ice and some really strong drugs that the doctor gives me. And I drink electrolytes all the time. So, hey, with any luck, we'll be out of this here. Thank you so much for the care, concern, and good advice. I don't think I'll be to turmeric poultice compress levels of desperation. And that, I'd probably just chop the feet off. Thank you so much for that. It's deeply appreciated. Well, so they didn't ask for an extension of time. It should also be noted that petitioner, through her prior counsel, filed a motion to quash the deposition, that she contested it and said, we don't think this should happen. Well, it was still pending before the court. In other words, the court had not told her she did not have to come to the deposition.
Shut the fuck up, Donnie.
She's making up her own rules is what's going on here. They agreed to the date. She didn't show up. They made the motion to quash, to shut down the deposition. That hadn't been ordered yet. She is still required to be there. So she's making up her own rules, just saying, hey, I ain't going to come tomorrow.
Phrasing.
Respondent provided his response objection on January 4th, 2023. No reply was timely filed, and no court order restricted this properly noticed deposition. Still, petitioner willfully, see attached, failed to attend. The reasons provided by petitioner's new counsel for not attending the properly noticed deposition failed to comport with Rule 57. In other words, the bullshit reasons we got for her not showing up were bullshit. They weren't among the rules that allow her, the exceptions that allow her to just not show up. And we'll be talking more about those. Rule 57 of the Arizona Rules of Family Procedure, as a result of petitioner's failure to attend and failure to adequately provide notice of her non-attendance, respondent has incurred attorney's fees and costs, which he's entitled to under Rule 57G. So not only did she not show up for no valid reason, they incurred a bunch of legal costs. Somebody got to get paid. And like, why should CLAYTON have to pay his lawyers who prepared for this deposition, who got ready, who showed up, who had nothing else scheduled because of him? Why should he have to pay when she violated the rules by not showing up? So he's asking for her to pay for his fees, which damn rightfully she should. Petitioner's counsel indicated that he will be filing for some sort of request for protective order. Judge, her lawyer said that he's going to file something. As petitioner's most recent counsel was advised in the correspondence attached, this is not valid cause to fail to attend a deposition and does not comply with the rules. The communications regarding the deposition are attached here too as Exhibit A. The court currently has a motion for sanctions pending. They've already got a motion for sanctions pending before the court. Respondent intends to reference this in notice in advancing the consistent arguments regarding appropriate consequences for petitioner's continued non-compliance with the rules, including legal fees and other relief available under law. So they're going after her for all the other shenanigans she's pulled, for costs and anything else they can get out of her. Plus, now they're going to add in the costs for the deposition that she did not attend. The end. That's what we're asking. That's what we want. And just wanted to let you know, Judge, she didn't show up. Now we've got the exhibits. Before we get to the exhibits, let's check out what's going on here. It's Marv White Marv White dropping $5 for the doggos, and I'm going to mention the Great Moonshine Conspiracy until you do a show on it. Can continue to do it. Continue to mention it all you want. Probably it would have to be a very, very slow week before we got there. Maybe a weekend show or something, but it's not in the foreseeable future. But continue to mention it. All right, this is Wednesday, January 17th. January 16th. Okay, so we got to go all the way back to the beginning and read it in reverse because that's how they organize their mails. Good. This is the email exchange between the lawyers, which I find to be remarkably funny for a lot of reasons. All right, there we go. All right, we will start here with January 11th. Hi guys. Good afternoon. In regard to the form of the above referenced matter, please see the attached notice of appearance that has been filed on behalf of the petitioner, Ms. Owens. Ms. Doe. A physical copy will not follow unless otherwise requested. Okay, so this is the new lawyer saying, here's the notice of appearance appointing me as her lawyer. I'll be appearing for her moving forward. The reply, I guess there wasn't a reply. Next day, January 12th, Mr. Woodnick, I intend to depose Mr. Eckert in my office. Please let me know yours and your client's availability on the following dates: February 1st, February 2nd, February 8th. Thank you. So this is her lawyer saying, "Hey, we're gonna depose your guy." Well, that gets a lengthy response from Greg Woodnick, Greg with 2 G's, because any dude that has 5 letters in their first name and 3 of them are G's, dude's badass. When 3 of the 5 letters in your name are G's. Corey, I'm a bit confused. As we were contacted by a different firm indicating they would be taking over as representation of Laura. Yeah, I'm a bit confused because we've got the Valley Law Group here, and he's dropping this thing. He's like, I'm a bit confused. We're contacted by a different firm indicating they would be taking over as representation of Laura. Now, under normal circumstances, and this case is far from normal, I would have brushed that off as maybe wires being crossed. But I think you will be there on the 12th or 13th, the lawyer in this melee. I think you will be the 12th or 13th lawyer involved in this case. So I want to make sure you are not already withdrawing. It has been a pattern here. So this was 4 days after they filed their notice of appearance on her behalf. So we're just making sure that you're not already withdrawing after 4 days, because lawyers don't seem to be sticking around. Been there, done that. Lawyer shopping. No, this is the opposite of lawyer shopping. These are lawyers saying, "Can we get out of this? We don't want to have anything to do with this anymore." Yeah, this is legitimately the opposite of lawyer shopping. This isn't like going through lawyers trying to find a better one. This is trying to find someone that will represent you. Her lawyers, they need permission to withdraw from the case, and they've submitted their permission slips from her, giving them permission to withdraw and stuff. Yeah, she's not lawyer shopping. Just her lawyers just don't want to have anything to do with her. So they're dropping like flies. She can't keep her lawyers very long at all. So you're the 12th or 13th in this. I just want to make sure that you're not already withdrawing. I like how it's italicized. Now, regardless, I'm just happy Laura has counsel because she represented herself for a minute there. He's just happy. I'm just happy she has counsel. This will keep our deposition on Wednesday productive. Reminding them, hey, we've got this deposition coming up on Wednesday. As a reminder, Laura is remiss in her discovery obligations. To date, she has provided none. She's under a court order to provide discovery, which is all of the documents she has relating to her situation and her claims. She has to provide all of the claim supporting documents. She's submitted none in violation of the court's order. And so, is remiss in her discovery obligations. That's a nice lawyerly way of saying your client ain't done shit. Per Rule 62, she needs to bring the requested documents to the deposition. Attaches Exhibit A along with a notice. I'm also happy to resend the blank HIPAA releases. They were ignored previously for her to execute. That's to get them, to allow them to have access to all of her medical records. She won't give those. She won't sign those. Also, as to your date requested to depose Clayton, of course we can make that work. And yes, we are available on Groundhog Day, 2/2. Just to point out it's Groundhog Day. I love that he points out it's Groundhog Day because this is the third time she has done what she's doing to Clayton. He's number 3. It's Groundhog Day. It's the same. It's the Groundhog Day, the movie reference. The same shit over and over and over again. I just love he's driving that little, just sticking it to her a little better. Yeah, we're available on Groundhog Day if that rings any bells on your side of the court. I'm just glad to hear Laura agrees that further discovery is critical. So we welcome the formal notice. Please dispatch for the record. I am requesting that we start a bit earlier, 8 a.m. at your office because it's on a Friday and I have other commitments in the afternoon. Isabel copied. Will be there with me. In light of your client's history, we don't engage with her without witnesses. Happy to talk offline today if you have a few minutes, Greg. So even the lawyers like, we're not talking to you without witnesses, because this lawyer was accused by her in representing the previous guy. The same lawyer represented the previous guy, and she accused him in a letter to the judge. She accused her opponent and his lawyer of drugging her and graping her in a letter to the judge. So he's like, yeah, that shit don't fly. We're not talking to her without witnesses present. So that was sent on January 15th at 1:19 p.m. January 16th, about 23 hours later, another letter. Corey, as a professional courtesy, I wanted to let you know, as I'm sure Laura is expecting, that I hope that expecting was an intentional dig, referencing her state of alleged pregnancy, as I'm sure Laura is expecting. I'm sure it's not, but I think it would be really funny if that was like a knock on her pregnancy situation. I wanted to let you know, as I'm sure Laura is expecting, there may be a police presence at my office tomorrow for the deposition. He's like, yeah, we even want the cops here. That's how little we trust her. I'm also attaching the vital records form for a fetal death certificate because, I mean, they are taking Jane to the woodshed. They're taking her to the woodshed with this because she did the dumb thing. She said she's no longer pregnant after the 20-week mark. And apparently under Arizona law, if a fetus over 20 weeks dies, it's not considered a miscarriage. It's not considered a stillbirth. It's considered a death. I mean, because apparently it was viable at that point. So you have to have a fetal death certificate after 20 weeks. So they're putting her on the smallest spot she can be put on. Either she lied about this whole thing, in which case no fetal death certificate was issued, or she had the baby somehow and didn't get a fetal death certificate, which could lead to murder charges, or 2, she's got a fetal death certificate and she actually was pregnant. And so here's the release forms. You just sign them and let us see the death certificate. So she's either going to have to prove she wasn't pregnant and therefore didn't need it, or she's got a lot of goddamn questions to answer about where is that post 20-week baby death certificate. Please encourage Laura to populate and bring to the populates, fill it out. Please encourage Laura to populate and bring to the deposition. My staff can notarize it for her there. She also needs to bring her Rule 49 and Exhibit A per Rule 62. The depo videographer, and this is nothing that they went to all the expense of getting someone to videotape it. The depo videographer is not inexpensive, and we just confirmed with John. Laura needs to be here at 1 p.m. for a prompt start. I do anticipate needing most of the 4 hours. We look forward to meeting you both in person tomorrow. Yeah. Show us the babies. No! Well, first of all, they're non-existent, apparently. But two, if they are, no. Yes, unfortunately, the populating, that's just lawyer speak. You always talk about populating a document. If you can hear all the chewing going on, it's because Strawberry is chewing on a bone right next to a blanket, where if she was chewing on the blanket, it wouldn't be making any noise. So any scratching noises you hear is Strawberry chewing on a bone. Dewey says, even if for some reason the judge seriously considered sealing these proceedings, the one person who has standing to challenge the seal as a third-party intervener is Dave Neal. Yeah, I can't imagine him sealing, but we'll get to those when we talk about the application to seal the documents here in just a bit. After this, we're going to get into that business. I hope this woman never actually reproduces. Oh, can you imagine the poor kids? God, poor stupid kids. All right. Well, let's continue with the email here. Scroll in. We get the reply. This was like what, an hour later? How was the time? It was 11:37. 12:22. So yeah, a little less than an hour later. Mr. Woodnick, thank you for your email. After reviewing this case more thoroughly, I'm writing to request your position on both parties signing a protective order under Rule 53 with relation to the deposition. What sort of protective order could they possibly want? Specifically, we will be requesting that the deposition transcript, testimony, and any supporting video is documented as highly confidential and kept under seal. Well, gee, why wouldn't she want anyone to hear or know about what was talked about during the deposition? What could she possibly have to hide? It just couldn't be redacted in some way. What could possibly be there? Oh, everything? Everything about what a piece of shit she is? What an absolute liar she is? How about that? That could be some stuff that she doesn't want out there. She doesn't want people to know. We will also request that the deposition scope is limited to matters relevant to this proceeding. Oh, depositions, you can wander far and wide on your questioning and depositions. Now, the person receiving the questions doesn't always have to answer them, but you can ask pretty much anything you want in a deposition. They don't have to ask them. They can give their objections and whatnot, but yeah. Assuming your client does not intend to annoy, embarrass, oppress, harass, or leak the information, bitch, please. How of all of the people involved in here, who is the one that is annoying, embarrassing, oppressing, and harassing whom? Who is the one doing that shit? I think it just might be Jane. No. Yeah. Yeah. They have the unmitigated gall. They have the audacity to say, we hope your client, Clayton Eckert, is not intending to annoy, embarrass, oppress, harass, or leak information about our sweet little innocent client, Jane. No. God, just the audacity of putting that in writing. I am hopeful that they would be able to sign this agreement for same and move forward with the deposition tomorrow. Please let me know your client's position as soon as possible. If we are unable to reach an agreement, I will be seeking court intervention prior to my client being present for any deposition. So if you don't agree, we're going to take it to the court, and my client's not showing up for deposition until then. Again, this is no reason to back out of a deposition so far. Well, this is January 16th, 12/22. We get a longer letter 2 hours later. Oh, people, she's making it worse. From Greg Woodnick. Corey. No hi, Corey. No dear Corey. Now we're just Corey. Corey. Pay attention here, Corey. CLAYTON will not be agreeing to a protective order for filing this case under seal. Your client went to The Sun, People Magazine, TMZ, Reddit, Medium, etc., and continues to post and contact the media to date. Also, it is highly doubtful that you will be able to meet the high burden to have a case sealed. Note, your client already tried this and was denied relief. Yeah, she's already done this once. If you weren't aware of that, maybe you're not caught up on the file yet. Maybe you haven't seen everything in the file, but yeah, she's already tried this and it didn't work. 2. I just like how now he's just gone to numbering. It's not just the free-flowing conversation. He's numbering the paragraphs now. 2, as you are aware from the pleadings, we will absolutely be addressing the malignancy of her allegations, including her historic prior allegations, as they are directly relevant to her bad faith motivation to file this matter. Note, your client also repeatedly refers to her prior pregnancies in her emails and text messages to CLAYTON, which were disclosed. Moreover, her prior allegations are entirely relevant to our motion for sanctions, as she has a history of fabrications, and her playbook in this underlying matter is almost identical. Some of the texts read likely they are cut and paste from the Gillespie matter. The Gillespie matter is the one immediately prior to this. He's like, this bitch is doing something so close to what she did to my previous client that it looks like she actually cut and pasted some of the text messages. You're goddamn right we're talking about these earlier incidents she's involved in. You're goddamn right we're talking about them. We appreciate that subject matter of fabricating pregnancies is embarrassing, but her responses to the questions are absolutely relevant to the pending action in court. Yeah, any embarrassing that happens, she's done it to herself. Alan Walsh says, I'd like to know who's entitling these fucking loonies. It's them that need to be jailed. I think her father's financing this, I think, or her mother, somebody. She's got well-to-do parents, you know. She has some sort of podcast. Ugh. 3. Your objections at deposition are obviously limited by law. If Laura attempts to terminate deposition because we are asking questions that are directly related to her sanctionable actions, that is obviously your choice. I'm fairly confident that Judge Mata is not going to agree with you, and she will be exposed to consequences, including attorney's fees and paying for the reporter costs for yet another deposition so that the discovery process can be completed. 4. I have zero intention of asking questions that do not serve a legitimate purpose. Now, what Greg thinks is a legitimate purpose and what Corey thinks is a legitimate purpose may be entirely different things. But Greg's saying, anyway, I'm not going to ask questions that I don't think serve a legitimate purpose. Much of our time is going to be spent confirming foundation issues because your client, after she claimed she was no longer pregnant, insisted on exercising Rule 2. 5, last, no matter what questions we ask, your client will claim they are meant to harass. I assure you that is not the case. So no matter what we ask, your client's going to bitch and whine about, oh, you're just harassing me. No, we're not. That's not what we're trying to do. And 6, I trust Laura told you that she had the opportunity to avoid this by acknowledging that she was never pregnant with CLAYTON. That offer still stands. She can make this go away. That's the condition they have. That's the condition that Greg has set down for allowing her to withdraw the lawsuit, for allowing her to pack her bags and leave. That's the one, as far as I can see, that is the one single condition he's put on it, that they sign a document saying she was never pregnant by CLAYTON. That's all she's got to do, and she gets to walk away. She won't do it. She said if he signed that paper, it would be perjury. It would be perjury if I signed a paper that said I was never pregnant by CLAYTON. Mm-hmm. Well, 6. Okay, we just did 6. Last, this deposition was properly set 3 weeks ago. And I have spoken to 2 other lawyers for Laura in that window. If Laura is now refusing to participate without her demands being met, it is not only an unreasonable request based on the history here and her publications, but a late one. You are more than welcome to call me to discuss. I appreciate you were in a difficult situation having taken this case in this posture. I understand you're in a really bad situation with your client. You know, it sucks to be you taking on this case. I appreciate it. You're in a difficult situation, but you know, we gotta do this. we're gonna go do it. Hey, yeah, this is just a thing. Chat, if you want to talk about other people's streams, go watch the other people's streams. We don't. This is the only stream we're worried about here. If you want to talk about what's going on other people's streams, feel free to go check them out. Just saying. Right. This is what we talk about here. That's a bannable offense, by the way. Encouraging people to go over to other streams or talking about what's on other streams, that we just don't do that here because this is my channel and my show, and that's what we talk about here. Anyway, just letting you know, not upset, nothing egregious going on, just letting you know. So all right, he comes back later that day, a couple of hours later. Is Jane Doe's name Laura? Yes. Shh. It's Laura Owens. Laura Owens. Shh. Yeah. Greg, I appreciate your understanding of the interesting situation I walked into in this case. That sentence is so telling. That sentence is so telling. This is Corey's. You remember he said, probably like with this much sarcasm, I understand the difficulty of you taking on this client in this situation. I understand that. And Corey, her lawyer, says, I really appreciate your understanding the interesting situation I walked into in this case. He's admitting, holy shit, what have I walked into here today? What have I done? Yeah, I am now involved in this case, whether I want to be involved in it or not. I'm here. Holy crap, this is a, quote, interesting situation I have walked into. This, to me, right in that very first sentence, says, thank you for understanding that I am in way over my head. I'm way over my head. Thank you for understanding. I know you and I are in opposition on this one, but I hope we can represent our clients with the understanding that we're both simply representing our clients and not take issue with each other for doing so. Let's hope our next case together isn't so contentious. This is him also being like, look, you know, don't hate me just because I'm representing my client. I hope we can like work together on other things that are not this insane. Don't hate me. Just, you know, don't beat me up for representing my client. This poor lawyer. This tells me that he doesn't really want to be involved, but he's here now and he has to do his job representing his client. After speaking with my client. So at least At least he went and presented Greg's conditions or Greg's email, the items he listed in his email to his client. After speaking to my client, we will be filing a motion for a protective order relating to both parties' depositions of each other. So he's like, oh, okay. Well, to be fair, let's seal both of them. Let's seal your deposition and our deposition. How's that? That'll be fair, right? Right? We can seal both of them. No. I will have this filed by the time of the deposition tomorrow. My client will be awaiting further order from the court with relation to this before subjecting herself to Mr. ECHARD's deposition of her, and she will not be present for the deposition tomorrow. That right there is a big thing. That right there is a big, big thing. She's under a court order to attend this deposition. All of the preparations have been made, and there has not been a court order or an exception granted to her not to attend that deposition. But here is her lawyer saying, to be clear, my client is going to violate the court's order, and she ain't coming to the deposition. She's not going to be there until the court gives us further order from the court regarding our motion for protective order. You can't do that. And he's covering his ass here. He's covering his ass in a big way. He didn't say, I have advised my client not to attend. I have instructed her not to attend, or my client. He's just saying my client is waiting for this. This is him just saying, I'm telling you what she said. This isn't me. I'm not advising her to go against the court's order, because that would be really bad for a lawyer to say, ignore the court's order and you don't have to come. So, yeah, this is him covering his ass by saying, hey, my client, she's just going to wait. She will not be present for the deposition tomorrow. To be clear, this is not my client saying she does not want to be deposed. Again, nothing about, I'm not saying my client, this is him covering his ass in a huge way. My client says, and see, when lawyers are lawyerly with each other, they'll say, well, we advised our client, or as per our advice to clients, or as we told them, or as we explained and were instructed. We will use words like that. When you see something that like my client says, that means the lawyer does not want to sign off on that statement. That's generally a good signal that the client has gone rogue and the client is telling you to do something that you have told them not to do, or you've advised them against. So that's when you see communications from lawyers and things like that, pay attention to what they're like, the actual literal words they're saying. My client saying means I got nothing to do with this. So to be clear, it's not my client saying she doesn't want to attend. I believe her motion to quash adequately stated and put Mr. ECHARD on notice of this, but instead that the deposition should be confidential to avoid continued embarrassment and annoyance as she has undergone thus far in and outside of these proceedings. She just doesn't want to be embarrassed and harassed and annoyed. She doesn't want to be annoyed. She doesn't want to be annoyed by the lawsuit she filed. That's rich. In order to allow the court to weigh in on this deposition and request for confidentiality appropriately, Ms. Owens must seek this leave prior to the deposition. Thank you, the Valley Law Group. So that was January 16th at 4 p.m. Okay, the next morning, Corey, pay attention again, Corey. Corey, I appreciate you letting us know that Laura is not planning on showing up to the noticed deposition this afternoon. Thank you for telling us that your client is going to violate a properly noticed court-ordered deposition. Thank you. That said, and see, you called it, and as I'm sure you advised her in a cover your ass letter, Clearly, this is like, I'm sure you have somewhere in writing to your client the statement that you cannot do this. You must come to court. I'm advising you to be there, and you would be committing a very grave error if you were to just skip the deposition without being allowed to do so by the court, my dear client. So I'm going to send this letter saying you're not coming against advice of counsel. That's what he's saying. As I'm sure you've advised her in the CYA letter, she's not allowed to simply ignore a properly noticed deposition. See, Greg knows Corey doesn't want to do this. Greg knows Corey has told her that you can't do this. Corey knows that Greg has sent a letter to her going, bad, don't do it. I'm advising you not to do this. Well, in light of her actions and exercising efforts to save Clayton costs, we're canceling the court reporter. We will include the anticipated cancellation fees required by the service in our cost statement and append to the anticipated China doll affidavit. Note, we will prepare an affidavit confirming her non-appearance and send you the same after 1 p.m. That was the motion we just read. I mean, that was the notice that we just read. The matter has been set for trial. Laura needs to comply with Rule 49, and she has provided zero disclosure, notwithstanding you being the third attorney. Rule 49 is a disclosure, I guess. So she hasn't given us any disclosure, and you're her third attorney. I've communicated with this. The third attorney I have communicated with about this FC case, the family court case. I am sending you again. The fetal death certificate form I provided to you yesterday, and submitting for the third time HIPAA forms attached for each of the following providers: Dr. Zeman, Tamara Lister, NP, Dr. Makul, Dr. Higley, and PPC, so we can get the records directly from the source and consistent with her testimony in court already. As I explained to Lexi before she quit the case, that was her lawyer that was there for about a week and filed a motion to withdraw the case, and that was about all she did before she left. She was only a lawyer for 1 week. As I explained to Lexi before she quit the case, we will not accept any records from your client that are not given to us from the providers directly. Why that? Why not? Why wouldn't they accept them from her? Why do they want them directly from the source? Well, she's already reportedly and very seemingly falsified a sonogram. She's doctored other documents reportedly and apparently. And so they're saying, look, if she hands these documents to us, we don't trust it. We think it's bullshit. So we want it directly from the hospital so she doesn't have the chance to doctor the documents and forge them. In fact, he goes on right here in the next sentence to say, this is an arts and craft history here. Her cutting and pasting and copying and editing out timestamps it's an arts and crafts for her. She has a history of performing arts and crafts on the evidence. I love that sentence. There is an arts and crafts history here. That's a good line. I hope someday in my life I have a chance to use that phrase. There's an arts and crafts history here with your client and their evidence. Fortunately, Laura herself invoked Rule 2, so she should be more than cooperative with signing these releases so we can get the records from the source. I am disappointed, but certainly not surprised that the deposition is not proceeding today. Disappointed, not surprised. That's Exhibit A. What do we got down here for Exhibit B? There is no Exhibit B. All right, it's all Exhibit A. So that's the end of this whole notice of non-appearance thing we've got going on. It's I so want her lawyer to come on this show after, not her lawyer. God, I don't even talk to, and I don't know which one I would choose. I so want Clayton Eckerd's lawyer to come onto the show here after this is over so that I can talk to him. I really desperately want to interview this guy. And he's brilliant and he's hilarious. This is for lawyers. This is funny. I don't know if it's like hilarious to you guys, you non-lawyers, but between lawyers, this is some funny shit. This is some funny writing. Gigi, you're leaving us. Bye. Yeah, go do your grown-up stuff. Cough, cough, cough. All right. Oh Lord! All right, we're halfway through here. And what we're going to do is we've got the motion for confidentiality and preliminary protective order, and we've got isn't this like the worst redaction you've ever seen? Like they didn't even try. they didn't. They tried about 50% is more than the people that didn't do anything in the last one. But anyway, we'll do the motion and the response, and then with the time remaining, we'll go back and we'll look through the evidence that's attached as exhibits and evidence in other stuff we haven't talked about yet. Yeah, no, the redaction is pretty much shit, but who cares at this point, right? We're just having fun calling her Jane Doe. The rest of the universe knows who she is. But we're here on the halfway mark. Let's see how our poll is doing. Let's see what's been going on over here in poll land. See, it's like Poland, but not really. It's like poll land. Anywho, we got 601 people here, 351 likes. That means like 300 of you, almost half of you haven't done your job. I would just be super, super grateful, super, super happy and honored if you would do me the favor going down and hitting that like button to get the word out that this is what we're doing, to get it showing up on people's feeds, to get it front page on people that are interested in following the ECHARD case or the Bachelor or whatnot. Get it on there for us so that we can all see what's going on. I would be deeply, deeply appreciative if you would get down there and smash the like button. And also, if you would hit the subscribe button. We're on our push. We're pushing for 67,000 subscribers. We've picked up 7 since we started. We're at 66,917 so far. So we're 23. We're 83 away. 83 subscribers away from 67,000. That's my goal. Let's see if we can get there. So I would appreciate it if you just do me the honor and the privilege and the pleasure of subscribing to my humble little channel as we continue to grow and bring you serious cases like Maya Kowalski and hilarious bullshit cases like this and everything in between. I would appreciate that. Thank you so much. And then come over here and take our like and subscribe poll. How are we doing on the like and subscribe poll? I sound like Daryl Brooks over here. Grounds, sustained. Subscribe, like, and vote. Your favorite euphemism for Jane Doe condition. 9% of you like the term crusty Claytons. 15, I hate that. That is just a nasty term. I hate even saying that. 15% of you say Jane Doe. That's kind of unpleasant too. 24% of you say mouth conceptions. And yes, there are mouth conceptions about her pregnancy. That's my personal favorite. I'm proud of mouth conceptions, but only 24% of you like that one. A full 51% of you, more than 52% of you, now back down to 52. Yeah, okay, we're fluctuating between 51 and 52%. Enjoy the phrase tonsil twins. So tonsil twins are the clear favorite, and I don't expect anything to be swayed at that point. Now see, look, we've got 474 votes and 389 likes. Like literally 100 of you have cheated by taking the poll without hitting the like button. Okay, that's all I'm going to say about that. All right, let's get back into this. We got some more grounds to cover. Just wanted to point that out. We got the like and subscribe thing, and do a little bit of subscription grift. That's what we're into these days. We're into grifting subscriptions. Hey, we got 3 more, so we're exactly 80 subscribers away from 67,000. Do you, Clayton ECHARD fans, do you, Jane Doe haters, do you guys want to be responsible for getting the 67,000 subscribers on this stream? Well, you go right ahead and give it your best shot while we look at the motion for confidentiality and preliminary protective order. This is what Corey said that he was going to file so that they could seal the deposition, so it couldn't be used to annoy. And let's see, we don't have any of the super chats or anything to read, and we're about looks like we're about 65 away from Doggo Cam, so we're far away from that as well. All right, here we go, kids and adults. So I don't know why I called you young whippersnappers kids. I gotta stop doing that. All right, petitioner Laura Owens. Hereinafter petitioner, that's been redacted. Jane, no! By and through undersigned counsel, hereby files this motion for confidentiality and preliminary protective order pursuant to Rule 53, Arizona Rules of Family Law Procedure. Petitioner requests this court sign and adopt the proposed protective order attached hereto as Exhibit 1. as a formal order of this court, or to issue its own protective order as deemed suitable. So either use our protective order form or just give us one of your own, Judge. We'll take either or. Statement of, now this is some shit here. Now, those of you that have gone through the Murdoch documents with me, those of you that have gone through the YNW Melly documents with me, those of you that have gone through the Maya Kowalski documents with me, you know that each and every time a lawyer files a motion, they give you an unnecessarily long rehashing statement of facts. They go through every pertinent fact again and again and again and again. It's lengthy, it's long, it's pages and pages long, all of the background facts and details for their case. Notice what she's done here. On August 1st, 2023, petitioner filed her petition to establish paternity, legal decision-making, parenting time, and child support. On August 21st, respondent filed his response to the petition. On December 28th, petitioner filed a motion to dismiss, and on January 4th, respondent issued a notice of deposition summoning her to attend a deposition scheduled for 17th. January 11th, undersigned. What are we missing here? What are we missing here? We're missing what would be in almost every background statement of facts. This day, this year, this month, this day, my client met with so-and-so. They did this. She gave him a couple of blowies. They went into the other room and they knocked boots or whatever. There is no explanation of anything that occurred before filing the lawsuit. None of the grounds for the lawsuit are mentioned in this. That right there is highly suspect to me. She won't even say how she got pregnant in this motion to seal the details of the deposition about her getting pregnant. She is not giving up any information. It could be also that her lawyer is not letting her put the information in there because he has to put his name on the bottom of it. But for some reason, all of the pertinent information. See, this is the barest bones statement of fact I have ever seen in my life that I can recall. Seriously, no joke. She's not putting any details in there. Oh, Urza has sent us the link to the article. Thank you so much, Urza, to the Cosmopolitan article I was looking for earlier. And so it looks like Island has done that too. So thank you everybody that sent that. We'll do that next time because we got ahead of our game here. All right. Just kind of checking here. Oh, we got to wait. What? We got memes being sent too. Spit fellatio pregnancy test. No, we can't. No. Spit fellatio pregnancy test. Get clear results before you go to court. Under 0% accurate. Can't detect shit. Easy to read for psychos. Ew. A spit fellatio pregnancy test. That might be one of the worst memes I've ever seen in my life. All right. So we can read a lot. That's terrible. General T, that is a terrible meme. Shame on you. The absence of any information about the actual statement of facts. This is a procedural list here. This is not a statement of facts. This read between the lines and you figure out why she's not putting any details as to how she got pregnant in here. Allegedly. So on January 11th, undersigned counsel filed his notice of appearance on behalf of petitioner. On January 16th, undersigned counsel emailed legal counsel representing respondent asking if respondent would agree to a preliminary protective order. Respondent declined. Following the referenced January 16th mail exchange, undersigned duly notified opposing counsel of his intent to submit this motion. It was also conveyed that petitioner would seek the court's issuance of a protective order prior to her deposition. Again, undersigned counsel mailed asking if undersigned counsel asked respondent if they would agree. Here we have, it was also conveyed. I just passed along the news. That's another cover your ass statement to the judge. Say, hey, judge, that's cover your ass speak for, hey, judge, it ain't me. I'm just conveying the information I received that she will not be attending the deposition. A chappie says, how do we send you memes? Because I got memes on Twitter, I guess, Twitter DMs, the legal vices. That's probably the best way, I guess. I don't know. But I don't do locals or Discord or anything like that because I find them annoying. So, anywho, what could possibly be the law and argument for this not attending a properly noticed deposition? Rule 53 ARFLP allows the court for good cause to enter an order to protect a party or persons from annoyance, harassment, oppression, or undue burden or expense, including one or more of the following. Forbidding the discovery. So the judge can just forbid the discovery, specify terms and conditions, including time and place for discovery, prescribing a discovery method other than the one selected by the party seeking discovery, or forbid, this is what they're going for forbidding inquiry into certain matters or limiting the scope of discovery to certain matters, and designating the persons who may be present when the discovery is conducted, and requiring that a deposition, they're also going for number 6, so 4 and 6, requiring that a deposition be sealed and opened only on court order, and requiring that a trade secret or other confidential research, development, or commercial information not be revealed or be revealed only in a specified way, and requiring that the parties simultaneously file specific documents or information in sealed envelopes to be opened as the court directs. So they're going for number 4 and 6. They're going the forbidding inquiry into certain matters and requiring them to be sealed. So yes, they are allowed. They are allowed to apply for this, and they can be granted under certain circumstances. Well, furthermore, Rule 53D also allows the court to enter an order that limits a party from disclosing information or materials produced in the action to a person who is not a party to the action. A party seeking confidentiality must show why a confidentiality order should be entered and continued. Okay, that I agree with. Whoever wants the confidentiality must show why the confidentiality is necessary. And the party opposing confidentiality must show why a confidentiality order should be denied in whole or part, modified or vacated. The burden of showing good cause for an order remains with the party seeking confidentiality. So yeah, they have the party seeking the confidentiality has the burden of proving that it needs to happen. Additionally, Rule 53.2 requires that the court make findings of fact concerning any relevant factors, including but not limited to any party or person's need to maintain confidentiality. Well, she's a public person, so she says her own bio describes her as a public person, so the need to maintain confidentiality of such information or materials is weak to begin with. Any non-party or intervener's needs to obtain access to such information or materials. And again, someone like Dave's case, I would argue that it's absolutely necessary that he obtain access to these because he's being sued for defamation for saying that she's not pregnant. So he should be entitled to receive all of these documents about whether or not she's pregnant. Truth is an absolute defense. And CC, wow, I get like 2 there. Any possible risk to the public health, there's no risk to public health or financial welfare, et cetera, et cetera. Case law directly citing Rule 53 is sparse. There's not a whole lot of case law on this because it doesn't happen that often. However, as the commentary for Rule 53 states, Rule 53 is based on Rule 26 of the Arizona Rules of Civil Procedure, which provides additional insight and case law on the subject. Rule 26C1 similarly provides that upon good cause shown, court may make various protective orders that justice requires to protect. They're just restating the same thing over and over again. Requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. It lists a couple of cases. The text of Rule 53 provides the court with no fewer than 8 separate non-inclusive means by which it might ensure that the party is, again, he's not shedding any light or proving why he needs this order. He's just restating what the rules say over and over again in different ways. There's 8 ways that ensure a party is not subjected to annoyance, embarrassment, oppression, or undue burden or expense. In other words, the rules provide the court with broad discretion in fashioning orders for parties or information entitled to protection. Let's see if we get on more here. Petitioner's proposed protective order attached here to and incorporated by reference requests that relevant discoverable information, which either party designates as confidential, remains confidential. Oh, so if we say it's confidential, you have to keep it confidential. That's what he's asking for. If we say something is confidential, then the opponents have to keep it confidential just because we said it's confidential. That's what he wants. That ain't gonna happen. I can't imagine that happening. That would be retarded. And it's not disseminated to anyone other than the parties and the respective counsels, including if one party objects to the confidentiality designation and until said designation is removed by the court. Oh, so if we say it's confidential and you disagree, it's still confidential until the court says it's not confidential. The court does not want to get involved in this pissing contest. I can tell you that right now. The court is not going to want to say, all right, everything you object to, let's have a hearing on every one of these things that you don't want to disclose. Yeah, the court does not have any desire or interest to become involved in that. The protective order also seeks that any party depositions in this matter, if deemed appropriate by the court, are designated as confidential until either party requests that the court make an evaluation into whether parts of the deposition or deposition's entirety should have the confidential designation. I can't remember how long this goes. Let me just scroll down around page 4. It doesn't. Okay, good. It goes to page 6. I didn't think of 7. I didn't think it was very long. I just thought it was 32 pages with the exhibits. I didn't want to read 32 pages of this. This is a guy who doesn't have a lot to say. So we're on page 4, and the statement of facts was a few lines. So for basically 2 pages, he's just said the same thing in about 5 different ways. But there's no substance to it. Respondents requested an anticipated discovery will further annoy, embarrass, and oppress petitioner. Well, boo fucking who? Boo fucking who? At this point, I think it would be warranted. Okay, Chappie, I cannot show that meme. I cannot show that meme. Artist recreation of Jane Doe getting pregnant with twins. It's an uncanny X-Men picture of Storm in a rainstorm that's like splashing all over. We can't show it. I wish I could show it because that's legit funny, but there's no way in hell I can show that meme. Wow. All right. Respondent anticipated discovery is sensitive in nature. It's not sensitive in nature when she's filing the damn lawsuit about it. And should be protected. Respondent intends to depose petitioner or is seeking discovery relating to several sensitive and potentially privileged topics, including her previous sexual relations. She made it the issue. This is a pattern of behavior she's exhibiting. Her previous sexual relations, specifics regarding the sexual encounter with respondent. The receiver of the act is ready and willing to talk about everything that happened that night. And in fact, he has. But she doesn't want the specifics regarding the encounter revealed. Well, sorry, babe. You're the one that brought the lawsuit based on that allegation. You need to describe how it happened publicly in these public documents. Previous pregnancies. She's admitted to having 2 abortions. So however many other times, including the non-pregnant pregnancies, I have no idea. But she has previous pregnancies, discussions surrounding potential abortion or adoptions, her privileged medical records, her miscarriage. Okay, now is this a previous miscarriage she's had? It better be. It better be, because if they're calling this a miscarriage of these twins, it's actually a non-live birth thing. And you've got to put your death certificate in, the fetal death certificate. So this better be about another miscarriage, which would, I guess, be 2 abortions, a miscarriage, and then at least 2 fake pregnancies. We're racking up some numbers here. And other topics. While petitioner concedes that certain discovery may be necessary in this matter to appropriately litigate unresolved issues, including the issue of attorney's fees, this limited issue does not warrant the dissemination of sensitive information to non-parties in this case. Even though we understand that some things have to be talked, there's sensitive stuff we don't think other people need to know. Petitioner, get a load of this shit. Petitioner has already been annoyed, embarrassed, and oppressed by respondent's actions. His actions of defending himself in court and asking her to man up or woman up and to submit her evidence, that's annoying. That's harassing. That's embarrassing and oppressing. No, he's defending himself against your bullshit lawsuit. And all you have to do is sign the thing saying you were never pregnant and walk away. So petitioner has already been annoyed, embarrassed, and oppressed by respondent's actions and has concerns that this will only worsen as discovery continues. Respondent is consistently using his social media platforms to control the narrative of this case. Well, because you're not controlling the fucking narrative. Me and at least 2 other people I know of have invited you specifically to come on and control the goddamn narrative. You want to control the narrative? I will give you 2 hours. I will give you 2 hours to control the narrative. I'll give you 2 hours to walk us through your documents. I will give you 2 hours to tell us exactly what happened and control the damn narrative. Other people would do the same. He's controlling the narrative because you are refusing to even submit evidence to support your claims. God dang, this woman is annoying. She's so annoying, she raised my voice a good half octave. All right. need to loosen the vocal cords. Bring the pitch down a little bit. Okay. All right. All right. Bring our voice back down to a little more normal pitch than the agitated legal vices pitch that's like about up here. All right. Respondent is consistently using his social media platforms to control the narrative in this case. Respondent is an American television personality best known for his appearance on 2 seasons of The Bachelor, Bachelorette. Respondent has approximately 360,000 social media followers across Instagram and TikTok alone. See Exhibit 3. Respondent has also made appearances on multiple interviews and podcasts throughout this case where he has discussed this case or situation. Hey, you're still here. You're still here. Come on. Bring it on. As a result, petitioner has been the subject of disparaging comments, harassment, annoyance, and undue scrutiny from tens of thousands of individuals online. Counsel notes that specific instances of online disparaging of petitioner are not included in this motion, as counsel believes this would only encourage the conduct for the people following the case. To the extent that this court deems it appropriate and necessary, counsel will provide the court with specific instances of the public comments which are annoying and embarrassing petitioner across social media and online platforms. However, any such disclosures should be protected under seal and revealed via in-camera review with only the judge and attorneys present to avoid worsening the continued impact on the case of the petitioner. This deliberate effort to shape public opinion has created an environment that is not only emotionally distressing for petitioner, but also poses a potential threat to the fairness of the legal proceedings. Oh, I pretty much goddamn guarantee you they can seat 6 or 12 jurors that have no clue what any of this is about. I'm pretty sure it would be possible to find 12 people in that area that don't watch The Bachelor and have no idea what's going on. So that's a crock of shit. Petitioner desires to litigate the case on the merits. Oh, do you? How about you submit evidence of the merits then? How about you do that? Why don't you actually prove the merits of your case? Free from ongoing concerns that she will receive further annoyance and embarrassment from the public should aspects of the disclosure and her deposition testimony be freely disseminated to the public. Well, don't take someone else's dissemination and claim you got pregnant out of it then, okay? He disseminated in your mouth. That doesn't mean you got pregnant. Hey, that was a good joke. Come on. Thank you. Thank you. Thank you. That was a good joke. Come on, people. At least give me one lol. Anyway, all right. While petitioner concedes, okay, it's funny to me. If you don't think it's funny, fuck all y'all. While petitioner concedes that she also made comments to organizations, these efforts were in an attempt to clear up the many false narratives circling publicly. Join me on my stream. I'm not going to talk about coming with her ever. Join me on my stream to give your comments, to show me, to clear up some of these false narratives. Come on here and, well, I just did it again. Join me and clear up some of these false narratives about you, shall we? Shall we? I thought that was really funny. All right. I see that's the joy of being an introvert like me. I find myself really fucking funny. I laugh at my own jokes like hysterically all the time. The only issue remaining in this action is the issue of sanction or attorney's fees. It is undisputed that the parties do not share a child in common, and that petitioner is not presently pregnant. Dun dun dun. It is undisputed that the parties do not share a child in common and the petitioner is not presently pregnant. Does not say because she lost the children, because she lost the fetuses, because she birthed early and gave them up for adoption. Well, that would still be sharing a child in common. Or it doesn't say that she was never pregnant. Again, there's no light being shed. If someone was calling you, if you'd filed a lawsuit for paternity against somebody, and they were going all over social media saying your pregnancy is bullshit. First, would you doctor and submit a 7-year-old YouTube video as your own sonogram? But let's assume you had some fucking weird brain fart and that's what you did. You made a really stupid decision and you did that. Would you not submit absolutely everything possible to say, here, mother effer, here is the pregnancy test. Here's the sonograms. Here's the medical reports. Here is all of this. Stop dragging my name through it, you big, deadbeat motherfucker. You're trying to get away from your responsibilities as a man. Wouldn't you be doing that rather than just saying, we're not going to tell you whether I was pregnant or not. We're not going to do that because it's irrelevant now. Hell no. Hell no. You would be all over that shit. You would be calling his ass out, throwing every single medical document you could possibly get from any hospital to show that you are in fact pregnant with this mofo deadbeats twins. Exactly zero of that happened. None. So they're saying a deposition is unnecessary to seek the information a respondent would require to properly litigate the sole remaining issues. See, they're trying to Jedi mind trick and say the only issues left are sanctions and fees. No, the paternity is still an issue for him because he has to clear his name that he never impregnated her. So these issues still do exist. Sorry, Corey, you're wrong. You're dead freaking wrong. Respondent refused to agree to enter in any preliminary protective order, causing necessity for filing this motion. He gave you an out. Just say you were never pregnant. That's it. That's all you got to do. Sign that paper, notarize it, say you were never pregnant with his kids. The end. Given respondent's mainstream history of divulging information related to this case to the masses without issuance of a protective order, petitioner anticipates portions of and or her deposition as a whole. I only hope to God we get the whole deposition. All 4 hours of it will be discussed and or disseminated publicly, thus subjecting her to additional annoyance and harassment. Footnote. Counsel notes that in his limited time in this case, very limited time in this case, substantial amounts of information have leaked to the public or media within hours or days of the information being transmitted. This includes not only things like motions, but also emails between counsels and other details surrounding the case as well. Leaked isn't the thing. They're there. They're just not being leaked. They're on the fucking court docket. Any Joe Schmo on planet Earth can walk into the Maricopa County Courthouse and go, hey, I want all of the documents related to this case. They're not being leaked. They're public. Anybody can go get him, you twat waffle. Good Lord, you know that. Don't exaggerate. God. 3, if the court does not preclude the parties from conducting depositions of the opposing parties, the court should limit the scope of depositions to the present matter. In the event the court does not outright deny the party's ability to depose the other, the court should limit the deposition to the issues narrowly involved in the present litigation. Petitioner believes this should initiate with the party's act or alleged act of sexual intercourse. Petitioner believes this should initiate. should initiate with the party's act or alleged act. So they're saying they're not even saying a sexual act occurred. They're not even willing to go that far in their motion to seal it. They're just calling it an alleged act. A possible alleged act of sexual. They can't even say with the party's sexual act. With the party's act or alleged act of sexual intercourse. They won't, again, the lawyer may know more than he's letting on here. He won't even include the word, he won't stop with the party's act of sexual intercourse. He won't say that with his name on it. He had to say, or alleged act of sexual intercourse. In an email exchange between counsel, respondent counsel has expressed intent to depose petitioner regarding her previous relationships, which are entirely unrelated to this matter. Oh, except they're exactly the same facts. There is that. The court should issue an order designating confidentiality deemed discovery as protected and confidential. This present case is unique. It is not unique. You got another one exactly like it. It's not unique. She has a history of doing this shit, at least twice. This court is aware of the constant struggle within Arizona courts and laws, weighing the best interests of a child against the privileges. What child? There is no child. You've admitted there's no child. Why are you bringing child into this? Against the privileges designed to protect communications with certain professionals. While this case is still labeled as a family court case, the parties do not share a minor child in common, and therefore there is no obligation for petitioner to share protected or privileged information. Almost all the requested discovery to date seeks otherwise privileged information from the petitioner. It's not. While petitioner concedes that disclosure of certain medical records may become necessary to support her claims, they're still sticking with the claims. They're still trying. She's going to support her claims with medical records. She is uncomfortable disclosing such personal and private information without a protective order in place. Even then, petitioner should only be required to produce evidence establishing the viability of her claims instead of all medical records or HIPAA releases as respondent has and will likely to continue to request. So in conclusion, for the reasons set forth, issuance of a protective order is necessary and can be accomplished without any material prejudice to either party. As such, petitioner asked this court to sign the proposed form of preliminary protective order attached here to his Exhibit 1. Doing so will protect the parties, yada, yada, yada. Sincerely, Corey Keith for petitioner. Yeah, Exhibit 1. This is the old protective order. This is the wording for the protective order. It's lengthy. It's unnecessary to read. I think the chances of it being given are really, 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 really small. And here's the emails that were exchanged that we've just read. And Exhibit 3 is his social media showing that he has 296,000 followers on Instagram, on the grams. Hey, he has his own B&B. There's a request for pre-decree mediation. I have no idea why that's in there. But anywho, that is her motion to make all of this shit confidential. And this is his response. Let's see, how long is this response? Good. It's also 6 pages. Oh God, it's 10 pages. Whew. We gotta buckle down and get going on this because we are. Can we get through 10 pages in the next 20 minutes? That's the question. All right, got to readjust myself here. My feet, ow. All right. Gotta take another drink. Strawberry, you having fun with that bone?
Yes, you are.
All right, we have 1-starred comment. What do we have over here? It's Jinver, Tonsil Twins sing. Nice Thompson Twins blast there. Doctor, doctor, can't you see him? Thompson Twins are awesome. Anyway, sorry, I was just like going through, I cycled through about 3 Thompson Twins songs in my head. Okay. Oh no. Doe had fun with the bone too. Oh. We just can't talk about this case without innuendos, can we? It's just pointless. Anything about coming, anything about size, anything about bones, and we are so limited to what we can talk about without the joke being made. I'm just gonna give up. I give up talking about this. I mean, I give up just like not trying not to have innuendos. We're just gonna roll with it. Why not? Hey, we're at 934 subscribers now. That is awesome. We are 66 away. Only 66 subscribers away from 67,000. That is awesome. Thank you, everybody. The 34 of you that have subscribed since we started. Yeah, there's 677 of you here now. 83 likes now. 483 likes. 200 of you haven't hit the like button. Get on there, smash that. Let's get the likes up to 600, and let's get 66 more subscribers. I'm sure that there's 10% of you at least that haven't subscribed to my channel. Just hit that subscribe button, and you never have to worry about it again. That's a fair deal, isn't it? That's my humble little request. All right. Let's look at Greg's response to Corey's motion, shall we?
Let's jump in.
Hey, MG Law, what's up? Got an MG Law sighting. What in the hell is going on my phone? It's like 1 o'clock in the morning and there's a million emails coming in. What is this? Oh. Right. 10 pages. Let's go. Response objection to petitioner's motion for confidentiality and preliminary protective order. Let's see what Greg has to say, shall we? Respondent Clayton Richard, respondent objects to petitioner's unverified motion for confidentiality. This constitutes an impermissible restraint on protected speech. He's going with the free, and I have not read this document, so we're read. I just got this is what I was. This is why I was 3 minutes late. I was downloading this, so that's why we're late here. Danielle in the house. Also, what's up, Ma Danielle? Good to see you. All right. They're going with the free speech route. This sealing the record is an impermissible prior restraint on protected speech. Beyond that, it's also a tremendous overreach in the use of Rule 53 to diminish respondents' rights as a litigant. I think he could just sign his name right there and walk away and be done. Boom. Boom. I mean, that says it right there. It's a restraint on free speech, and it's an overreach to diminish his rights as a litigant. That's it. But, let's go through the details. Apparently, petitioner feels she's entitled to what is essentially a backdoor. Well, if there would have been more backdoor action, there would have been even less pregnancy going on. Backdoor motion to seal the back door. Always seal the back door. Fuck me. All right. Apparently, petitioner feels she's entitled to what is essentially a backdoor motion to seal after the court has already denied her attempt. Remember, she's already tried to do this once because after she contacted the tabloids, and the media to disparage respondent, the publicity she initiated backfired when it was exposed that she had engaged in previous pregnancy fabrications and that her medical evidence was lacking in science. Science.
Blinded me with science.
The entire underpinning of her petition to establish paternity was predicated upon a con/scam and a fraud upon this court. Petitioner has furthered her noxious agenda. Ooh, noxious is a good word. Noxious. I like noxious. It's a noxious. It's a good round word. Noxious. It's round, smooth. That's an old Monty Python skit. Sorry, my ADHD is kicking in huge right now. Just look up the funniest Monty Python skit ever. You'll think it's funny. The noxious agenda. By failing to appear at a properly noticed deposition, this occurred notwithstanding 3 different attorneys in a matter of weeks having discussed the deposition and ongoing discovery issues. Meanwhile, she continues to advance meritless lawsuits against the media and being David Neal and others, I guess, against the media for questioning the narrative she shared with the Sun, while simultaneously contacting the media. Well, ain't that the shit? Ain't that the shit? She's contacting him and complaining about people contacting him while she's still contacting them. Now petitioner has the chutzpah. You got to go with the chutzpah there to flout court rules and suggest this court ignore the First Amendment, while in the same breath arguing that she is entitled to protection by the court. To the extent applicable, respondent incorporates his pending filings as and for his response objection. He says respondent states as follows. Currently pending before the court are respondent's motion to leave to amend the respondent's response. This is all the shit that's we don't need. There's a bunch of shit that's in front of the court that is still pending. The court must begin with the presumption that prior restraint on protected speech is dubious and subject to the highest scrutiny. Petitioner does not address or even attempt to explain why prohibiting respondent from speaking about the issues she brought in this action would withstand constitutional scrutiny. She's trying to infringe on the First Amendment rights without even mentioning why or how and what justification she has for trying to infringe on the First Amendment rights. Bring the pitch down, Lorax. Bring the pitch down. Let's tickle the tonsils with some non-impregnating, what is this, ginger ale. Korean ginger ale. Okay. Yes, there we go. This is not the least restrictive means to accomplish the end stated, nor do the concerns petitioner expresses outweigh the substantial interest of respondents' freedom of expression, freedom of the press, and the public's interest in the open legal proceedings, etc. Plaintiff's demand would trigger a woefully unnecessary and inappropriate procedure overtly designed to thwart disclosure. Recall, she has entirely failed to comply with Rules 49, Rules 62, and Rules 57. Petitioner has not shown good cause for deviating from the ordinary process for petitioning the court for confidentiality or sealing documents when the court deems it appropriate. Here she seeks to hide behind Rule 57 as a justification for willfully failing to attend a properly noticed deposition and for continuing to fail to provide any disclosure going on 8 months. So she's not been she's been ignoring the deposition, the disclosure requirements for 8 months. Meanwhile, initiating contact with the media, publishing articles, and otherwise soliciting media attention. Yeah, you can't do that. You can't bring all this to the media, complain to the media, and then want the media to shut up when they say something you don't want to hear. The fact that discovery may annoy or embarrass petitioner does not mean that sealing and confidentiality are appropriate remedies. Petitioner not only brought this action in bad faith, but also she shared it with the media and even wrote a de facto op-ed furthering her fictitious narrative and painting herself as a victim. Absent from petitioner's motion is the petitioner filed the underlying action. Petitioner threatened repeatedly to bring her pregnancy to the media. Petitioner reached out directly to the media with her unsupported allegations. The Sun, People Magazine, TMZ, Reddit, Medium, and petitioner published information, including her alleged medical records about that case online. Petitioner now continues to contact the media to advance her fictitious narrative while simultaneously asking this court for special accommodations for confidentiality. This after the court already denied her motion to seal. Parenthetically, petitioner's efforts to seal the other case with nearly identical claims of being pregnant with twins and with similarly doctored sonograms was also denied seal protection. Yeah, in the last case she's fabricated using the same facts and using this same freaking sonogram apparently, or different, similarly doctored, not the same sonograms. She did it in the other sonograms. Yeah, it was also denied seal protection. Her conduct and legal position simply do not align. Petitioner is not special. I love that. I love that. 4 words. Those are 4 great words. Petitioner is not a special little old snowflake that deserves special protection. Petitioner, that's got to hurt her so bad. She wants nothing more than to be special. She wants nothing more than to be this public figure, podcast, brilliant person who's seen on the arms of uber billionaires and former football players, Bachelor contestants. She wants to be special. Well, Greg says petitioner is not special. Respondent does not doubt the petitioner will be annoyed or embarrassed by examination by oral deposition. You can just say deposition. You didn't have to say oral deposition, but I thought it was funny. But if that were the legal standard to oppose a deposition, the exception would be to swallow the rule. No, no, you did not do that, Greg. No. I am going to exert my absolute best effort to get Greg Woodnick on my show. Just for that one sentence. Oh, sweet baby dumpster Jesus. Wow. Oh, my Lord.
Gotcha, bitch.
Wow. All right. I'm stunned that holy God. That is brilliant. Oh, that is brilliant. Equality, bringing me back to reality here for a minute with a Canadian $5. Thank you so much, Equality, bringing us just saying hey. Hey, it's you, Equality. Sorry, the camera's over here. Hey, Equality, looking at you. Oh, no. Oh, lawyers are hilarious. And there's some freaking hilarious judges, too. I mean, there are some just absolutely screamingly funny judgments out there. And there's like lawyers will often try to, I mean, there's like judges who will make, poetry with their decisions. There's the lawyers will try to get in the occasional dig where they can, but this is sorry, I've wasted time. This is truly a genius sentence because I stopped at the oral deposition because I thought oral was just being a little extraneous. He didn't need to say oral. And holy God, if I just would have finished. All right, let's get back on. Let's get back on the road here. Oh dear.
Hey, stop fucking with Korean Jesus. He ain't got time for your problems. He busy with Korean shit.
Don't know why I played that. I just thought it'd be funny. Respondent does not doubt the petitioner will be annoyed or embarrassed by examination by oral deposition. But if that were the legal standard to oppose a deposition, the exception would swallow the rule. Oh, Lord. Every litigant is uncomfortable being examined under oath. That is inherent to the adversarial system the petitioner triggered with her filing. It is only when those burdens are undue. I'm sorry, that's beautiful. Oh, God, that is beautiful. I'm sorry. It's very unprofessional of me. Okay, it's only when those burdens are undue or the discovery process is abused that those concerns become sufficient grounds to prohibit discovery mechanisms. All litigants are entitled to use discovery for legitimate purposes, which includes gathering information, testing the deponent's knowledge and truthfulness, exploring patterns of past behavior, including other fictitious pregnancies, appearances under oath in court with a fake pregnant stomach, collateral proceedings, etc. And next time we do a Clayton and Jane stream, we're gonna be watching that fake pregnant stomach court appearance, collateral proceedings, etc., and other acts relevant for impeachment and or to show that the underlying case was malignantly filed. Moreover, petitioner cannot now evade deposition, critical for establishing evidentiary foundations after she invoked Rule 2. The fact that petitioner finds participating in the litigation embarrassing is no different from the experience of anyone else, except that in this case, she brought the petition, she made sensational allegations, and she threatened to and did bring media attention to the case in an attempt to control respondent's behavior and, disturbingly, to get him to sign a dating contract and to coerce him to explore intimacy with her. Yeah, that was pretty creepy. Not only is respondent entitled to the information and discovery necessary to defend against her claims, but she also has a fundamental constitutional right to discuss the nature of these claims. Oh, he also has a fundamental constitutional right to discuss the nature of these claims, just like any other litigant. Petitioner is requesting an order that would prohibit respondent from defending his character in public view, despite the fact that she made his character a matter of public interest and that she self-identifies as a public figure. The toothpaste cannot be put back in the tube. That was a good old Michael Moore thing. Back when Michael Moore was semi-sane, he did a skit where he was trying to get the people to put, like, the toothpaste manufacturer to put toothpaste back in the tube, but the toothpaste cannot be put back in the tube. Moreover, that the public is interested in the case only adds weight to maintaining transparency, not limiting it, even if petitioner now finds that interest uncomfortable after she invited it. Respondent has the right to depose petitioner pursuant to Rule 57, Arizona, blah, blah, blah. This is not in dispute. Petitioner has provided zero disclosure to date and now files this unverified motion alleging for the first time that she had a miscarriage? Okay, so that miscarriage thing was new. Again, which miscarriage is it? It's not a miscarriage in this case, is it? And is she going to say that she had it? Anyway, well, let's find out. Petitioner appeared on video during trial on October 24th wearing what appeared to be a moon bump, a device that used to appear pregnant, and asked the court if she could show respondent her pregnant stomach, which Judge Galiakitsis promptly denied. Note, the motion for protective order was filed after petitioner was copied with a spoliation notice to Amazon.com Inc. to preserve records confirming the purchase of said moon bump and to affirm the babies come from intercourse, not Amazon.com. Oh no. Oh no, that broke me again. But oh no. Okay, this is great. I love this. Greg, please, for the love of God, come on join me here. I quit. Greg, for the love of God, join me for a live stream one night. Oh God, that's funny. The motion for protective order was filed after petitioner was copied with a spoliation notice to Amazon.com Inc. to preserve records confirming the purchase of said moon bump and to affirm that babies come from intercourse, not Amazon.com. On November 2nd, 2023, petitioner testified that she was 100% and 24 weeks pregnant by respondent and that she was due February 14th. Yeah, how convenient that she is going to have her babies on Valentine's Day. Of all of the 365 days in the year to choose from, magically is Valentine's Day that she's going to have the children. Wow. Petitioner specifically testified that she was having a high-risk pregnancy due to her alleged epilepsy. She hadn't even proved she has epilepsy. And that she was being seen by Dr. Makul and Dr. Higley. To date, petitioner has provided no verifiable information to support these allegations other than doctored sonograms, ostensibly from Etsy, a borrowed YouTube video of an actual sonogram, and positive HCG tests. That's brutal. Petitioner then filed a motion to dismiss, claiming for the first time that she was no longer pregnant, but still refused to provide any information whatsoever about what happened to the alleged twin fetuses. Now, for the first time, she alleges that she miscarried. That is a salient fact in dispute because respondent does not believe that petitioner was ever pregnant, and certainly not by him, as they did not have intercourse. Moreover, again, clearing up the mouth conceptions of Tonsil Twins. Moreover, if petitioner did miscarry that late into pregnancy, a fetal death certificate would be produced and there would be corroborating medical records. Respondent has repeatedly asked for this death certificate and even provided the vital records request forms to petitioner. Due to petitioner's historic refusal to provide any medically verifiable information to support her allegations and her testimony of arts and crafts, medical evidence, written discovery is not sufficient. She does not get to dictate which discovery rules apply to her.
Am I the only one around here who gives a shit about the rules?
A deposition is the most efficient and least burdensome way to ascertain the validity of petitioner's claims under oath. Her fear of inculpating herself criminally, perjury, filing false police reports, etc., is the antithesis of good cause. Limiting respondents to the alternative means of discovery referenced on page 6 of petitioner's motion would incapacitate respondents' ability to obtain relevant and necessary evidence. Ironically, petitioner also requested respondent's deposition immediately upon hiring her current attorney, i.e., before taking any other action to address the supposedly burdensome discovery. Petitioner first retaliated by scheduling respondent's deposition. Petitioner cannot have her cake and eat it too. One of the very most famous misquotes in all of history. Marie Antoinette never did say, have her cake and eat it too. It's brioche. But that was a let them eat cake, wasn't it? Yeah, that was a let them eat cake. Never mind. I'll shut up now. Focus on this. Oh, God. This is funny. This is really funny. Respondent is entitled to depose petitioner about all relevant matters, including similarly false pregnancy allegations made against past putative fathers and inconsistent statements admissible for impeachment purposes. She ate the frosting, though. Porcelain Thunder, go to the penalty box. That's a 5-minute penalty for instigating that. She ate the frosting, penalty box for you. Jesus. All right. Not only do these allegations speak to her credibility, but they also establish an overt and escalating pattern of fraudulent behavior and abuse of the legal process. Respondent cannot properly bring his counterclaims of non-paternity, sanctions, and attorney fees without deposing petitioner and receiving definitive statements under oath about her past actions. The scope of inquiry absolutely includes relevant questions about past relationships that resulted in similar threats and legal actions brought by petitioner in writing and in prior litigation. Emails and text messages she sent to other men with nearly identical verbiage, prior doctored evidence, factually similar matters about which petitioner authored editorials, TEDx talks, and podcasts, and petitioner's medical and associated health conditions. After discovery, nothing prevents petitioner from seeking confidentiality or other appropriate protective orders as to limited portions of the deposition if the court were then determined they exceeded legal scope. However, preventing those questions from being asked in the first place would improperly limit respondent's ability to defend himself and stymie this court's ability to make findings pursuant to the law. In addition to the misuse of court procedure, there are significant First Amendment concerns here. Prior restraint against relevant discovery is an extraordinary remedy that is not remotely warranted in this matter. Petitioner has not shown good cause to override respondent's legal rights, the public interest in transparent proceedings, and this court's legal and equitable duties. Petitioner's prospective concerns after willfully failing to comply with the court's rules for 8 months are nothing more than an opaque attempt to thwart this court's ability to make findings. Petitioner cannot simply seek generalized and speculative relief as a means to justify a blanket restriction prior to providing any discovery, participating in a deposition. Moreover, her objections are not valid grounds for a willful failure. I'm getting riled up here. Moreover, her objections are not valid grounds for a willful failure to appear for a validly noticed deposition. 6. It is premature to designate as confidential documents, recordings, or records that do not exist and have not been produced. That's a very good statement. Sorry to wipe my nose there. That's a very good statement. It's premature to designate non-existent documents as confidential. I like that. To the extent a response to this assertion is warranted, there is nothing to be designated confidential. No deposition has occurred due to petitioner's willful failure to appeal. Petitioner has not provided any Rule 49 disclosure, and there are no exhibits or sensitive documents in the court record that could be designated confidential, even if petitioner has shown good cause. Simply put, petitioner's request is impossibly premature.
Phrasing
is impossibly premature, and the discovery being sought is relevant, including the HIPAA releases referenced in her motion. Oh, calling him to task for misspelling HIPAA, that's good. Further, and contrary to petitioner's assertions, discovery cannot be conducted during trial. True. All right, this is the last page we got here. Then we got a couple super chats I see lined up. We'll get to those here in just a quick second. Number 7. Number 7, respondent is entitled to his reasonable attorney fees and costs incurred responding to this motion pursuant to the rules. After properly noticing petitioner of his intent to depose her and agreeing to that date and time, petitioner willfully failed to appear. Instead, petitioner filed this motion, which alleges speculative relief that cannot be granted, seeks unconstitutional prior restraints on protected speech, and lacks good cause. Petitioner's unreasonableness in this matter only persists as she continues to seek out new ways to evade the disclosure and discovery obligations for the action she filed. Petitioner has a history of being creative and coming up with ways to avoid legal accountability. She previously made more aberrant allegations in prior proceedings involving similar false twin pregnancy allegations against an officer of the court to evade court appearances, fortunately foiled by Judge Bacchus, whose judicial assistant intercepted petitioner's ex parte effort, which was subsequently addressed to proceed. What? What the shit? She tried to say that an officer of the court got her pregnant with twins too? Like a lawyer? Oh my Lord. As a result of petitioner's behavior, respondent continues to incur attorney costs and fees, having to defend his right to exercise the discovery tools available to all litigants. Even Yoda says this is bullshit. Right, Yoda? Is this bullshit, Yoda? Yoda. Is this bullshit? Yeah, it is. Yeah, I agree. It's bullshit, huh? Yeah, right. Tell her it's bullshit. Tell her, Yoda. Thank you. All right. As a result of petitioner's behavior, respondent continues to incur attorney's costs and fees, having to defend his right to exercise the discovery tools available to all litigants. Respondent requests this court permit him to file a China doll affidavit. I don't know what a China doll affidavit is. That'll be something for me to research because that's the second time it's been mentioned. Wherefore, respondent requests this court enter the following orders. Deny petitioner's motion for confidentiality and preliminary protective order in its entirety. Award respondent his reasonable attorney fees and costs incurred due to petitioner's unreasonableness, and for such other relief as this court deems just and proper under these circumstances. We've upset Yoda. Bulldog barks never sound like it. These barely sound like barks. Other bulldogs like French bulldogs are the worst. They have like the worst barks known to humans. All right, that's the shenanigans for today. Next time we do this, we'll talk about the other cases we mentioned. The one in the Cosmopolitan article about the woman who was defrauding midwives, Canadian doula midwives, by getting them to assist her with non-existent pregnancies online, and the one who actually did get pregnant from fellatio. We'll talk about those, and we'll also we'll watch the video. We'll watch the hearing video with her and her alleged moon bump. Yeah, we'll watch that hearing. Whew. Right. Equality. Oh, just saying, hey, we already did that one. Thank you, Equality, if you're still just saying, hey. Island with the $5 super chat. I tried. I searched Tonsil Twins and Mouth Babies on Amazon, and they're also unable to deliver. I'm on another list now, aren't I? Yeah, you're probably on another list for that. And the DCV Titan. So, does this meet vexatious litigant yet? No, probably not. I mean, she's only done this like 3 times. There's people that are professional litigants who, that's how they make their living. They file frivolous lawsuits against companies for slip and fall things, for things that go wrong in their life. This doesn't rise to the level. I mean, it's, unfortunately. Wow, people. There we are. That motion, that response was funny. Oh my God. Swallow the rule. Great. That was brilliant. Hey, Yoda, what's up? Hey, Dougie, what's up? Right. Well, I can't wait to hear Megan cover this one. That'll be fun. All right, folks. Thank you so much for being here. Let's see how we did it. We got halfway to Doggo Cam. All right. Tonsil Twins seems to be the runaway leader on the what we think, what's your favorite euphemism. So we'll go, moving forward, we'll refer to them as Tonsil Twins. 10% of you said Krusty Claytons. I'm so glad that was last place. That is a horrible thing to say. And 15% was Jane Doe's Doe. And 24% was my mouth conceptions. All right. And 52% was Tonsil Twins. Oh, I should have put up Schrodinger's twins. That would have been funny too. All right, that's how the poll ended. Thank you so much for everybody that liked it. We're only 50 likes away. 50 likes away from 600. Just for shits and giggles, everybody go down there and hit that like button. Make sure we get up to 600 here in the next 2 minutes before we shut this down. I'm looking for a place that we can be redirected to. And we've got 941 subscribers, 66,941. That means we are 59 subscribers away from 67,000. Cool. So everybody subscribe to the channel. Let's get us up to 67,000. Everybody on replay, if you've watched it this far, please do that as well. Let's see. Where can we send y'all here now? Let's see who's doing what that I find particularly interesting. All right, go to customization, redirect, check. Oh, Danny on Direct is doing her missing mom trial, day 8. Let's go and say hi to Danny on, everybody. Let her know that Legal Vice has sent you. Let her know that you appreciate her and like and subscribe to her as well. We're going to go on over to Danny. Yes, Danny still is streaming, so we're going to head on over there. Mods, thank you for being here. All of you, all 600 plus of you that were here today, thank you so much for joining me for this. We're going to be doing this again next week with the hearing video of her with the pregnancy bump where you can see it all for yourself. Tomorrow, we're going to be looking at the criminal investigation, the police interrogation of Zachariah Anderson. We'll talk a little bit about his case for those of people that aren't familiar with it. He was accused of stalking and murdering his ex-girlfriend's the couple of week boyfriend, and the case was an absolute shit show. He was convicted with almost zero evidence. And we finally got his police interrogation video. And we're going to watch that tomorrow. Thursday, O.J. Simpson closing arguments. Johnny Cochran is up. And Friday, we'll be looking at the Aguilar Mendez case, the Guatemalan boy who was beaten by 4 cops and then charged with aggravated manslaughter of one of the officers because one of the officers with all these medical conditions dropped dead about 5-6 minutes after the arrest. That's what we got coming up for this week. Everybody take care. Thank you so much, chat. Thank you so much for being here. Mods, Vice Squad, you guys rule. Let's go say hi to Danny on Direct, and don't let her forget that the Law Rack sent y'all there. Take care, everybody. We'll see you tomorrow for Zachariah Anderson. Peace out.